Hi friends, good morning. Welcome to Annamaya IAS Academy. This is Dr. Harinath Reddy. Today in this particular video, we will try to discuss an important topic under Indian judiciary. So the topic is contempt of court. So many a times this will be in the news. For example, in 2020, Prashant Bhushan, the senior advocate, one of the senior advocates in the Supreme Court, who is also known as activist judge, he was punished for the contempt of the Supreme Court. And earlier we had the example of Arundhati Roy, etc. So in this context, what do you mean by contempt of court? So if you want to know the definition of the contempt of court, you should look for a legislation which was made in 1971, Contempt of Courts Act 1971. That we will discuss little soon. And this contempt of court, the expression contempt of court is not defined under the Indian Constitution. So the Constitution of India does not provide a definition for contempt of court, but the Constitution of India provides for punishment for contempt of court. There is one article in the Indian Constitution, Article 129. So Article 129 gives the power to the Supreme Court to punish for the contempt of the Supreme Court. And the Supreme Court is a court of record. Similarly, one more article, Article 215, it gives the power to the High Court to punish for the contempt of the High Court. So in other words, there are two articles which allow for the Supreme Court and High Court to punish for the contempt. One is Article 29 dealing with Supreme Court and Article 215 dealing with the High Court. Remember, both Supreme Court and High Court, they are called as court of record. Then what is a court of record? A court of record is one in which the judicial proceedings and orders of the court are permanently maintained and recorded. So Article 129 and Article 215, they say that Supreme Court and High Court are a court of record and they have the power to punish for the contempt of both Supreme Court and High Court. That is laid down in Article 129 and Article 215. But remember, the Constitution of India does not define the expression contempt of court. Questions have come in the UPSC prelims exam in the following way. Which one of the following statements is right? The contempt of court is defined in the Constitution of India. The contempt of court is not defined in the Constitution of India. Something like that. And where this contempt of court is defined then? So to implement the provisions of Article 129 and Article 215 and to provide for the procedure for punishing for contempt of court and to prescribe punishment for contempt of court, Parliament has made a law in 1971. This is called the Contempt of Courts Act 1971. Under this law, there are two kinds of contempt, civil contempt, criminal contempt. What do you mean by civil contempt? If there is any willful disobedience to a judgment of the Supreme Court or the High Court, which means willful disobedience means that if you are not interested in implementing the judgment of the Supreme Court or High Court willfully, then that amounts to civil contempt. In addition to that, if you breach any undertaking given before the Supreme Court or the High Court, willful breach, that is not following, willful breach of an undertaking given before the High Court or the Supreme Court also amounts to civil contempt. Then we have criminal contempt. So under criminal contempt, there are three things. So when do you say that there is a criminal contempt of the Supreme Court and High Court? So if you try to lower the dignity of the court, High Court or Supreme Court, or if you interfere with a judicial proceeding, or if you obstruct the administration of justice, then you can be charged with a criminal contempt, lowering the dignity of the court, High Court or Supreme Court, interfering with a judicial proceeding, obstructing the administration of justice. If any of these three things are done, if all of these three things are done, then that amounts to criminal contempt. Then the punishment which is prescribed under the 1971 law for the contempt of court is simple imprisonment of 6 months or 2000 rupees as fine, or even both of them can be levied by the Supreme Court or High Court. But remember, please remember, the subordinate courts do not have the power of contempt. And if you want to punish anyone for the contempt of a subordinate court, this can be done only by the High Court. High Court can punish. High Court can punish an individual for the contempt of the subordinate courts. That was laid down in section 10 of the Contempt of Courts Act 1971. Then there was one person by name Kunal Kamra. He was a comedian. So stand-up comedian Kunal Kamra has faced in the past the charges of contempt of the court because he criticized the interim bail which was given to Arnab Goswami. Then, in addition to these, the other people who are involved in the contempt cases before the Supreme Court and High Court is Prashant Bhushan, the activist lawyer, a senior advocate, and Rachita Thaneja, Arundhati Roy. Then, before we discuss the judgments of the Indian Supreme Court on the contempt of court, what is the procedure to be followed for initiating a contempt of court? So in this case, P.N. Duda versus P. Shivashankar. P.N. Duda versus P. Shivashankar. In this case, the Supreme Court said that there are three methods. One is the Supreme Court and the High Court can initiate the proceedings of contempt by themselves. The second method is the Advocate General in each High Court is the law officer. He is the officer of the court. So with his permission, contempt proceedings can be initiated. And if it is the Supreme Court, with the consent of the Attorney General or Solicitor General, contempt proceedings can be initiated. The question is, why the consent of Attorney General or Solicitor General at the level of the Supreme Court? Why the consent of the Advocate General at the level of High Court is made a requirement for initiating the contempt proceedings? We know that the time available before the High Court and Supreme Court is very valuable. If frivolous petitions are filed before the High Court and Supreme Court, and this will lead to a lot of waste of the court's time. So to save the valuable time of the Supreme Court and High Court, the Advocate General at the level of the High Court and Attorney General or Solicitor General at the level of the Supreme Court will go through these petitions, and if there is any valid requirement, then only they will give consent and allow the petitions to go before the Supreme Court or the High Court. This is to save the time of the Supreme Court and High Court, that we need the certification or agreement, approval or consent of Solicitor General or Attorney General at the level of the Supreme Court or the Advocate General at the level of the High Court. This does not mean that any contempt of court needs to pass only through Advocate General or only through Attorney General. The Supreme Court and High Court, they can assume the powers on their own motion, because it is an inherent power which is laid down in the Constitution. So the power of the Supreme Court and the High Court to punish for contempt, it is not derived from a law made by Parliament. It is already there in the Constitution of India in Article 129 and in Article 215. So that's what the Supreme Court said. Then, in this case, in 1995, there was one important case, Vinay Chandra Mishra, 1995. So in this case, the Supreme Court said the power of the Supreme Court and the High Courts to punish for contempt, it's an inherent power which is derived from the Constitution of India itself, from Articles 129 and 215. It means the provisions which are laid down in the law of 1971, the Contempt of Courts Act 1971 by the Indian Parliament, is not any limitation on the power of the High Court and Supreme Court. In other words, the Supreme Court and High Court have unlimited powers to punish for the contempt of the court. So they don't need to have the limitations imposed on them by the law made by the parliament. A law made by the parliament in 1971 cannot put any limitation on the High Court and Supreme Court when they exercise their powers under Article 129 and 215 for punishing for the contempt. That is the view taken by the Supreme Court in Vinay Chandra Mishra case of 1995. Then later on in one more case, Supreme Court Bar Association versus Union of India 1998. So in this case, Supreme Court Bar Association versus Union of India 1998, in this case the Supreme Court has taken a different stand. In this case the Supreme Court said the High Court and Supreme Court, they have the power to punish for contempt, but the quantum of punishment which is to be given is not the discretion of the Supreme Court or the High Court. It should be as per the law laid down by the Parliament in 1971, that is the Contempt of Courts Act 1971. Then there are two exceptions to contempt of court. One is fair criticism. If any judgment of the Supreme Court or the High Court is criticized without any intention to lower the authority of the court, without any intention to bring down the dignity of the court, that is allowed. For example, we have a person by name Faizan Mustafa. Faizan Mustafa, you all know that he was an expert on constitution. He was a constitutional expert. He also served as the Vice Chancellor of Nalsar University, Nalsar National Law University of Hyderabad. Now he is working as Vice Chancellor in Chanakya National Law University in Bihar. So this man says, I am trying to give an example for fair criticism. There was a doctrine called doctrine of essentiality.